From a brokerage standpoint, how can you legally protect yourselves and eliminate risk or mitigate risk from the carrier standpoint? Back by popular demand, Rob Hassman. If you have not heard him on previous episodes, I highly encourage you to go back and listen to those. Rob is starting to build a reputation for absolutely bringing some heat. So we wanted to bring Rob back and talk about something that is often overlooked but extremely important. Broker carrier contracts. How important are those, and what can brokerages do to protect themselves?
Well, first and foremost, not only are they extremely important, because they are, but quite honestly, they're going to be required. And not because you're going to require them, which you are. As we talked about in former podcasts, you're going to have customers come at you with contracts, right? And inevitably, you're going to see in these contracts that you are required to engage motor carriers that have signed a contract that say, da-da-da-da-da-da-da-da. So when you work with your third-party customers and you use carriers, inevitably, in a roundabout way, you're going to be required to have carrier contracts with these carriers out there. And if you don't, you're going to be in breach of the contract with your customer. So you're going to need that. Just as importantly, if not more importantly, you're going to put a whole bunch of other stuff in there above and beyond what your customers want to see to protect yourselves. So I think it's hugely important to, have a broker carrier agreement created early on in your brokerage. I see a lot of times brokers pull the TIA form and just run with that. It is not a horrible document. I'm not even going to say it's a bad document. I would say it is a document that is designed to be a catch-all maybe, and it's not narrowly or specifically tailored to the particular client, or particular brokerage house that is using the document.
Let's say newer companies or newer brokerages, they go out, they're looking to get all their ducks in a row, carrier broker contracts. From a broker standpoint, again, if you're listening, brokers do not own any assets. Brokers contract to asset-based companies. So they'll go online or they'll reach out to an attorney and say, hey, I need a contract between our contracted carriers.
Sure.
And a lot of times they're using something they find online or a TIA contract.
Well, a lot of times people starting out don't even call an attorney, and they'll just join the TIA and pull their document. Sometimes they'll hire attorneys that maybe have the TIA or don't practice in this area and just have a cookie cutter form. And again, there's not necessarily anything wrong with that, but in my opinion, you're going to want to seek out a specific transportation attorney with a lot of experience in this arena. Because if I were to show you the document that I have developed over many years, you're going to see a lot of stuff in there that's a bunch of legal stuff that would be the same stuff you see in the TIA document or in, a document you might find online, which is very important stuff. But you're going to also see a whole bunch of provisions in there that you may think, well, I don't, maybe this isn't important, or that doesn't seem like a legal thing. And the reason those provisions have been crafted or inserted into this document is because over 17 years, I've been in thousands and thousands and thousands of crazy scenarios in this industry. You guys are in this industry. You know that it never ceases to amaze you, the kind of crazy shit that happens. So I have developed ways and provisions that go into these documents to address a lot of those things. And quite honestly, to combat the way that insurance processes claims, to combat the way that motor carriers potentially try to argue against claims or against obligations and things. And these documents can be created. And, I have one that may be for a hazmat broker. I have another one that may be purely produce. I have one that's a catch-all. So the document, just like if you're going to, buy a house. Ideally, you could use the realtor contract, but it may not be, specifically tailored to your situation. If you come to me and you're the buyer, I'm going to have a contract written in the buyer's favor. If you come to me and you are the seller, I'm going to have a seller-favored contract. I'm going to try to craft a document for you that meets your brokerage house's needs, and again, comes with all the knowledge, experience, and expertise that I've developed over the years. Because one perfect example. Customer says, well, I don't want to salvage this. Insurance says, well, we have the right to. I might have crafted a document or a provision that states the motor carrier has to require its insurance to abide by that. Or, a lot of times insurance companies say, I'm not talking to you, brokerage, because you don't own the cargo. Therefore, you don't have any rights to a claim in the first place. I have provisions in there where the motor carrier has agreed that a broker can process the claim on behalf of its customer and that it has to require its insurance to speak with and facilitate the claim on behalf of the broker. That way you can stay in the process. And those are just two examples of things. But you're going to want to come up with a contract that not only deals with all the legal things that you're going to be required to make sure the carrier does, like have its insurance, safety rating, comply with laws, CARB, the list goes on and on and on, waiver of certain things. But you're going to want to make sure you address things that maybe a document off the internet hasn't thought about. So getting a great broker carrier agreement in place is very important. You want to make sure that that gets signed by all your carriers before they pick up any loads. Okay?
So how does that work? For people listening, there's various carrier onboarding platforms.
Right.
However you want to do it. You have your contract in place. Anyone that you are going to work with, let's say a carrier is their first time load. You are onboarding this carrier. They must sign your contract and be onboarded into your company in order to run that shipment, correct?
Sure.
Okay.
So, and I understand what you're getting at, Justin. You're getting at, I don't want to have to call these carriers every time there's a change or every time, I get a new contract. So what I like to do for my clients is some of them will get a wet signature. Some of them have an online portal that carriers go in and sign up on. They click a box, they sign an electronic affidavit or whatnot. And they have agreed to, there's a timestamp at the bottom of the document they agreed to. It might be broker carrier agreement version 7, okay? And at the time that they agree to that broker carrier agreement, it's all stored in metadata. Well, I like to include a provision in that broker carrier agreement that also says that by signing this and continuing to move loads for my client, you agree that any changes to this broker carrier agreement found in the broker's terms and conditions of services found using this link will be incorporated into this document, okay? And this terms and conditions are also important for motor carriers who won't sign your broker carrier agreement. We'll get into that in a minute. But that way, you can develop a set of terms and conditions. And, laws change. Things change. We have new circumstances like this theft issue we were talking about a couple podcasts ago. We have seal issues that are constantly evolving. So anytime you change this, if you have a living set of terms and conditions on your website that can be found at a link, and the motor carriers agreed in the version it's signed that anytime you change that, if they pick up a new load and sign a rate con, they will have agreed to changes to the document. You can update the broker carrier agreement to a current version that they will agree to in real time. You should probably have that looked at every year to 2 years for changes in law and changes in circumstances. So again, you're going to have your carrier sign the current version when they sign up. Again, not all brokers do this. There's a lot of expense that goes with these things. Things can be added over time, but you're obviously always going to try to have your carrier sign a rate confirmation anytime you broker a load with them.
Correct.
Same thing, in the bottom of that, you would embed a link and say, by moving this load, you agree to our terms and conditions found at UmptyUmp on our website.
And this is for, let's say we've been working with a carrier for years. You update our carrier broker contract. The next load that they run, once that's updated, they are acknowledging.
Or when they sign that rate con in real time to move a load tomorrow, it will have, this is something I've developed with my clients. I like to have a link at the bottom of that says, when you agree to move this, you're agreeing to the most current version of our terms and conditions which supplement your broker carrier agreement by moving this load and signing this rate con. So when they sign your rate con, they have re-agreed to your terms and conditions found on your website in real time. That's also important for motor carriers who do not sign your rate con or your broker carrier agreement, because if they say, I don't sign that, and they sign your rate con and it has that link, we have an argument that they have agreed to all of your terms and conditions. And by the way, your terms and conditions are really just a reorganized form of your broker carrier agreement. So that's another way to get them bound to that sort of thing. It's important not only for the legal things, but let's say that you end up having an issue. By having them on the hook to your broker carrier agreement, your terms and conditions, for you guys, you can haul them into court here in Hamilton County, Ohio. You don't have to go somewhere else to chase them. You can get your attorney's fees, court costs, and expenses paid if you have to go after them. Those are hugely important things on a $10,000 claim. So those are ways to keep your broker carrier agreement current. Now, the other thing that this isn't bulletproof, but let's say you have a motor carrier, but we have used this, our law firm, and it has held up. I'm not saying that every judge in the country is going to hold this up, but we've used it. You can also create, terms and conditions at the bottom of your email that you send out. And you could do this for customers and for carriers. And you could say, as a customer, if you book us for a load, you have agreed to all of our terms and conditions found, and you can create terms and conditions of shipment. Theoretically, your customers will have agreed to that if they book you. Now, I've not gone that route, but you could also have in those terms and conditions at the bottom of your email that by moving this load for us, you agree to our terms and conditions. So if they haven't signed your broker carrier agreement and have not sent back a signed rate-con, you have an argument that by accepting the load and by email from you with those terms and conditions, they have accepted them. And we as attorneys, if we have to, can theoretically go to court and say, hey, they moved this load. It says right here they've agreed to it. Again, I'm not going to say that that's 100% bulletproof and couldn't be challenged, but it gives you a very strong argument and at least gets you far enough down the path where you can usually get some sort of conversation with the other side because you have some leverage at that point. So that's kind of in a 50,000 foot view, what I would say would be a good way to lock down motor carriers on the intake and make sure that they're abiding by all the legal terms, conditions, and provisions that you would want to see.
No, that's extremely valuable. In like previous episodes, a lot of these things, from a sales standpoint, we don't think about.
Right.
We're running. You've seen me walk plenty of times. We're running 1,000,000 miles
I've been
per
to the
hour.
grocery store with you. I couldn't keep up.
I have a lot of things to do and places to be, Rob. But I'm a fast walker. If you're listening and wondering, I'm a very fast walker. But from a sales standpoint, we're moving 1,000,000 miles per hour. The last thing we're concerned about is a contract with a carrier. Like those things are just minute in our world. But having that mentality and changing that to no, those things are extremely important because at the end of the day, if something does go awry and this goes to court or we have to take legal action, we have to have that buttoned up so we're protecting ourselves and the company
Correct.
as well.
Not only with your action against the carrier, but if it isn't and you have a customer contract that says you would have done this and this and you didn't, you breached our contract, now we're going to hold you liable for the whole ball or yarn. If it says you will have a contract with a carrier that says it's going to have this, this, and this, even if the carrier didn't comply, if you can say to your customer, I have it, well, then you're off the hook. Now, to your point about moving 1,000,000 miles an hour as a salesperson, I get that. But Brian and I had a conversation, I believe, in the very first podcast that we did. These are things, the topics I'm going to talk about are the things that I would probably tell management and owners of brokers that are very, very important. None of your on-the-floor brokers are going to care or really concern themselves with any of this because all they want to do is say anything they can and do anything they can to get a load moved and get their commission. They want you to sign anything and do anything they can to get their customer on the hook, and they want to get any motor carrier they can to pick up that load and get it moved as quick as they can. So all these concepts, while hugely important, should be things that are concerning to two guys, setting up a brokerage with no employees, those two guys moving down the path, getting employees underneath them while they're still brokering, and then ultimately what I see is 2, 6, 7 guys that own a brokerage who have moved into more operations managerial and sales managerial roles. Their jobs are to put the protocols in place and make sure that the employees work within them. The employee's job really isn't to make sure these things are in place. That's kind of where I'm coming from with this.
Definitely makes sense, Rob. This insights, it's phenomenal. We appreciate you joining us again. If you are looking to learn a little bit more or are interested in potentially working with Rob, we'll include all of his contact information in the show notes you can find at the bottom of this episode.
Yep. Thank you very much. And anyone out there by any means, if you ever need any assistance or have questions or whatnot, just shoot me an email or give me a call.
I mentioned this already, but history of promotion. Someone that's like never settling, does not accept mediocrity. They're willing to put in the work to continue moving up, whether that's career-wise, financially, personal development, whatever it may be. Someone that wants more and is hungry for more.
Yeah.
Those are the type of people that I want.